Consumer Counterpoint, the video cast that we do bi-weekly, talking about consumer issues as they relate to class action litigation or mitigation of those risks. I'm Christine Argentine, one of your hosts.
And I'm Paul Yovanek. I'm an attorney in the Chicago office. And today we're going to talk about a recent decision that came out of California on the California Invasion of Privacy Act. Christine, can you tell us a little bit about that?
Yeah, sure. So this decision came out of the Northern District of California in about mid-October. It's a summary judgment decision, and it favors the defense on a SIPA, California's wiretap statute claim. It's interesting because we haven't seen many of these yet, right? We've had years of this litigation going on, but a lot of these cases are still at the motion to dismiss stage. And so this year in particular, we've started to see some more substantive opinions trickle down. We've seen some class cert opinions come down, some summary judgment, but really largely we're even still to this day seeing motion to dismiss opinions.
And I think here kind of twofold. Not only is it summary judgment decision, but also defense favorable.
That's right. I think so. The case is Doe versus Eating Disorder Recovery LLC, and it's a healthcare case. So
Sure.
Again, the first wave of cases that we saw in SIPA was a lot of healthcare cases. The allegations being that someone that visits the healthcare websites and where these tracking technologies are, that information, their private health information, is being collected and transmitted to those third parties that are running those tracking pixels.
Right. And so we get this summary judgment decision. Can you tell us a little bit about maybe what the court is? Because I've read the decision and I know the judge was very, very opinionated about SIPA as a whole, how it's being applied to this technology. So there's things that you can kind of pull from that for us. Yeah.
So the judge here, you're right, was pretty critical of the statute itself. And I want to pull some language specifically from the opinion because it is so significant in terms of just kind of an overview of whether or not we should be applying this statute with this technology for these types of cases.
Right.
And go ahead.
No, and I was going to say, I think just looking at the first page, I saw a little bit of the judge saying the language of SIPA is a total mess. Right. And then saying that it was a mess from the get-go, but the mess gets bigger and bigger as the world continues to change and as courts are called upon to apply SIPA's already obtuse language to new technologies. I mean, that's just saying a lot here.
Yeah, I mean, I think what this judge is really recognizing is this idea that the courts are being asked to take a 1967 statute, right, and apply that language that was drafted, which this judge didn't like from the get-go, to technology that was not even contemplated back then.
And I think we talk about this on so many other of our episodes of just old statutes, new technology. The plaintiff's bar is trying to just take this old language and say, aha, see, pixel tracking or biometric privacy, whatever it might be, and it's like we should fit this in. And we're now seeing judges kind of pushing back on that. We've seen it in TCPA too.
Yeah, and I think these judges, and this judge in particular, has allowed some of these cases through the motion to dismiss stage. Obviously, this one, probably there was a motion to dismiss that was denied.
Sure.
And so I think they are now capitalizing on this opportunity now that the evidence has been collected and they're getting to make these substantive opinions to, this judge in particular is taking an opportunity to give his thoughts on the statute as a whole, as well as kind of how he's viewing the elements of this statute in this particular case. And I think one thing that's significant is that this judge is strongly encouraging the legislature to take another look at SIPA. And he says that several times throughout his opinion, that the legislature really needs to go back and look at SIPA and try to figure out if it needs to be revised or if it needs to be completely rewritten or a different statute needs to be rewritten or written in order to cover this type of claim.
And it's interesting because I don't think that the court necessarily had to wait until summary judgment to say something like that, considering the fact that we're talking about a 1967 statute. Nonetheless, I do think it's reassuring to the defense bar that, while some judges, some courts might not feel comfortable making a decision on a motion to dismiss within the four corners of the pleading, have to accept the allegations as true and whatnot. Here, once we have discovery's closed and a summary judgment decision, like clearly judges are digging in now and taking a look at this, which has got to be reassuring.
Right. Yeah, I think it is, and it should be, because, whether or not these claims are viable, and, we've seen some of them go to trial, right? And be successful at trial. The plaintiffs has been successful on these claims, and obviously there are privacy concerns and interests. I think the problem with the statute itself, as this judge acknowledges, is that it's really hard for businesses to apply the language and figure out what they are supposed to be doing to comply, right? Yeah. It's just really ambiguous and really difficult. And I think what is important about this opinion as well is the judge acknowledges that this is a criminal statute. Right?
An argument that has been made by a lot of the defense.
Right. And so because it's a criminal statute, and because he found that the statute itself was ambiguous, he's applying the rule of lenity, right? Meaning that you are going to and supposed to interpret it narrowly, not broadly. Right? And so that kind of contradicts with what is being asked of the courts, right? If you're supposed to apply this statute
broadly interpret this statute, and it's like, well, wait a minute. Maybe that's not what we're supposed to be doing.
Right, and take this criminal statute and apply it to a very unique situation. Very, technology that it isn't talked about in the statute.
Technology 50 years later.
Right. So I think that that's an important point for the defense, obviously. And I think it's an important acknowledgement that this court made. And it actually factored into his opinion, right? So beyond criticizing the statute and its ambiguity and kind of its lack of application perhaps to these technologies, the court does still go through the elements of a SIPA claim. Right? And one of the things that the court looks at is content of a communication. So under SIPA, it's really about the interception of someone's intentional communication with another person, in this instance, a business operating a website. Right? And that has to be an actual communication with content, as opposed to what is referred to in these cases as record information, which is basic information, IP addresses, device information, basic URLs, which really aren't saying anything about the communication itself.
Right. No, that's interesting.
So what the court says there is that actually in this case, he's not going to grant summary judgment on the content piece, right? Because based on the evidence in this particular case and relying on those cases that talk about that a URL can be content, if it's more of a detailed URL, it contains really specific information. And let me back up a little bit with the technology itself, right? Part of what is at issue in all of these cases, and part of discovery and what everyone is trying to figure out, is what actually is being transferred. Right? What is this technology doing, and what data is that third party actually receiving?
Exactly.
And I think what is relatively accepted is that these tracking pixels are collecting page views, URL information, basic computer information, IP addresses, always, right? For this technology to work, those things are collected. Now, of course, there are all different types of technology an issue in these cases, and you can set that technology to collect more specific information. That's what I just listed as kind of the basics of, the technology itself, if you just kind of put it on there at default.
Right. I mean, and how much we could streamline some of these cases if we ever had the ability at motion to dismiss or something, just to show what are these tracking technologies collecting, what is it doing, but that's why we have to wait until summary judgment in many of these cases, even though, and sometimes I think the plaintiff's bar tries to exploit that a little bit of saying, well, the cost of class certification, the cost of summary judgment, as opposed to an individual settlement or a nominal class settlement. There's always those balances.
Yeah, I mean, unfortunately, these are very factually specific cases. The technology is complicated, how the technology is set up can vary greatly.
Yep.
And that, as a result, changes what data is transferred and what might not be transferred. So in this particular case, the court found and the evidence showed that the URL was including kind of more specific information about what that plaintiff was doing on the website. In this instance, right, researching anorexia, exploring treatment options, clicking through a self-assessment form. And because the evidence showed that that was the type of data being transferred, the court said, I think this does qualify as content under SIPA. And so he declined, even though the defense wanted him to dismiss on that grounds, that element of SIPA, he declined. And he said, no, I think this element is met based on the evidence.
Sure.
So what he then went to look at was the next requirement, which is the information, the content being intercepted in transit?
Okay.
Right? If you think about a traditional wiretap, right, when you tap someone's phone and they're getting that conversation at the same time the conversation is happening, that wiretap is capturing it. This is a little bit different, right? And it's interesting because the communications on the internet are essentially instantaneous. Like, we're talking about milliseconds.
Yeah.
But what this court found was that the content was not being read or attempted to be read in transit.
Okay.
And that is, one of the elements. And so the court found that because the technology company, the information is encrypted. So it needs to be received unencrypted and then potentially used, reviewed, read, learned, whatever that looks like. And so by its very nature of it being encrypted while in transit, it's not being read while in transit.
Right. So basically when it's going from one to the other, like this interception is encrypted such that how can you be reading and dissecting and kind of, examining this?
Right. And I think, certain technologies can unencrypt the information.
Sure.
It's not that it stays encrypted, but it's that they have to take that step of unencrypting it before they can use it.
It's like this active step of doing something more than just
Correct.
watching it go
Correct.
back and forth. Okay.
And another thing that the technology company at issue here said was that they have an automatic filtering system that when they receive the information, they filter out certain information automatically because they don't need it, right? They don't need it for whatever advertising purposes they're going to use it for,
Sure.
or for whatever reason they're going to use it for.
Sure.
And so it gets filtered out. And so what this court said was that filtering process can't be characterized as reading the
Sure.
content. So again, you've got a filtering process that happens after the data is received, so it's not being read in transit.
So it's like stripping away information, not necessarily reading it. It's just saying we
Correct.
don't need this.
Yeah.
Okay.
Now, the plaintiff did argue, right, that there was, if there's an intent to learn the contents while it's in transit, that kind of fits within the language of the statute. And the court acknowledged that actually was a stronger argument. But ultimately, the court used the rule of lenity and said, that's not going to work, right?
We're still dealing with a criminal statute.
I could see that interpretation, but it's ambiguous. It's not clear that that's what that's meant to mean, and so we're going to interpret this more narrowly and not accept that argument.
Okay.
So ultimately, the court granted the motion for summary judgment for the defendant on this idea that they had failed to prove the in-transit, the read or attempt to read in-transit element of SIPA.
Okay.
And it's a great opinion, right? And I think it's really helpful clarification.
Yeah.
It's going to
very
be
much.
really helpful, for defense going forward when we start to get to some of those substantive arguments. Now, of course, it's a trial court opinion, right? This could
I'm
get
assuming
appealed.
that the Ninth Circuit is probably going to be asked to weigh in on this. I mean, this is kind of a matter of first impression in many respects of just really getting this substantive decision at summary judgment.
Yeah. And we've had a lot of courts that are giving these substantive decisions very, very readily acknowledge we need some appellate court guidance
Of course,
here,
yeah.
right? If we're not going to get legislature to step in, which they have tried, right? I mean, I think, and this isn't something we've talked about yet, but there is a bill pending to amend SIPA to add a business exception, business purposes exception that would kind of apply to these types of tracking technologies. But that amendment, approval of that amendment or passing of that amendment got kicked to 2026.
Okay.
So as this judge in this case acknowledges, right now it's up to the courts, right? It's in our hands to interpret that. And what he said was, hopefully the legislature will go back to the drawing board on SIPA. Indeed, it would probably be best to erase the board entirely and start writing anew. But until that happens, courts should not contort themselves to fit the type of conduct alleged in this case into the language of a 1967 criminal statute about wiretapping.
Yeah, I mean, we have talked about this on other episodes too. I mean, going back to old statutes, new technology, the Illinois Biometric Information Privacy Act, the White Castle decision holding that every scan can be a separate violation of BIPA, and the Illinois Supreme Court saying this is what it says, and this is how we have to interpret it. And even just like this court did here, the Illinois Supreme Court said, hey, legislature, do something about it. And they did.
Yeah.
A couple of years later, they did. But it seems like this is exactly where we're at again. This is, once again, this old statute, new technology, trying to make a claim where it is a stretch, and courts are starting to see through on this. But again, this is what the statute says.
Yeah, and it's not that all substantive opinions have been defense friendly.
No.
But I do think that there are the cases that have either made it to trial or made it, got certified as a class. They are much narrower than some of these other situations where it's any visitor to the website or any person that did X, Y, or Z on the websites. There's some very specific situations where this technology is being used that has been, common across a class or substantively accepted as, fitting within. Now, the in-transit issue here probably would have, applied to those cases as well, to the extent there was a substantive decision the other way. But again, this is a trial court opinion, and I think, we're hopeful we'll see more.
Yep.
And we will see more, right?
Yep.
A lot of these cases are at this stage now and ready for these substantive opinions. And obviously we hope they're all defense friendly, but they're not all going to be. And so it is still important, as this judge acknowledges, that the legislature do something.
Yeah, I mean, we're going to end up with inconsistent rulings, and at some point we're going to get to a point where, court says this, court says that, but they can't coexist. The Ninth Circuit's going to have to step in if the legislature's not. I mean, there's going to be some issues here.
Yeah, and I mean, and we've got tons of cases pending. I mean, obviously a lot of this is happening in California. This happened in California about SIPA. Tons of cases pending in federal court, just as many cases pending in state court. So now you've got the California appellate courts that are going to start weighing in on this, and maybe the California Supreme Court. So, I mean, even there could be some inconsistencies in opinions.
Absolutely.
So it'll be interesting to see how this comes down. But overall, I think we are tracking all of this very closely.
Of course.
And we are really interested when substantive opinions come in like this, and we'll keep updating you all when they do.
Yeah, absolutely. Thank you.
Yep.